Foreclosure is a gut-wrenching, painful, excruciating ordeal. It threatens the very fabric of a family's unity, bond, and sometimes even very survival. Most homeowners feel completely hopeless, as if there's nothing that they can do against a very seemingly powerful, influential, and deep-pocketed bank. In fact, statistics show that more than 90% of homeowners don't even fight the bank. However, it doesn't have to be that way, and it shouldn't be that way. In fact, there are many legal options and remedies available to homeowners that, if exercised and utilized properly, could prevent the foreclosure and save their home. In fact, even foreclosure judgments, foreclosure sales can be vacated if there's fraud, collusion, mistake, or any type of collusion that is proved as a matter of at law. What does this mean for the homeowner? That means that the homeowner can now become empowered and no longer stay a victim at the hands of a notorious, sometimes well-documented predatory lender. Given the fact that New York State ranks second in the nation in mortgage foreclosure fraud, and New York City ranks first in the nation of all metropolitan cities in mortgage foreclosure fraud, it's not surprising that most of these cases, or a lot of these cases, are successfully defended and litigated with positive results for the homeowner. As a result of the many legal remedies and options available to homeowners, it is important that homeowners become aware of the path of a foreclosure state in New York so they can successfully litigate, defend, and hopefully reacquire the property that was lost. Now I'm going to discuss the paths of a foreclosure case in New York State. When a borrower becomes delinquent, typically between 2 to 3 months, the bank sends out a 90-day pre-foreclosure notice. During these 90 days, a homeowner has several options. The homeowner can negotiate with the bank concerning the loss, engage in loss mitigation discussions with the bank. The homeowner can pay the arrears. The homeowner can elect to sell the property and ultimately try to resolve the delinquency prior to the bank filing a foreclosure action. If nothing can be resolved at the end of the 90-day period, the bank mails what's called an acceleration letter to the homeowner demanding payment in full of the entire debt of the note. Now, if that is not paid, and typically it's not unless the homeowner enters into a contract to sell the property or engages in any other conveyance that would satisfy the loan amount, what happens is the bank files what's called a lis pendens in the county in which the property is located. The lis pendens simply is a legal tool that prevents the buyer from conveying the property to anyone else, and it puts the world on notice that this particular property is the subject of a lawsuit. Now, after the lis pendens is filed, soon after, the bank files a legal document called a summons and complaint. A summons and complaint is the official legal notice that's filed by the bank in the county clerk's office in which the property is located. That is the beginning of the legal action, the legal proceedings taken against the homeowner to foreclose on the homeowner's property. After the summons and complaint is filed, the homeowner must be served notice that the action to foreclose on their property is pending in court. The summons and complaint is served on the homeowner in one of two ways. The summons and complaint is either served personally through a process server hired by the bank, where the process server would go to the homeowner's residence and serve a copy of the summons and complaint on the person who is listed as the defendant in the action, which would be the homeowner. If the summons and complaint was served personally, the homeowner has 20 days to file what's called an answer. An answer is a response to the complaint. And in the answer, the homeowner can raise the legal defenses, counterclaims, and any other issues that are relevant concerning the foreclosure action. If the summons and complaint is mailed, a homeowner has 30 days in which to respond. Now, these are two very crucial time periods that a lot of homeowners oftentimes neglect to adhere to. It's very important because failure to respond in a timely fashion would enable the bank to file a foreclosure judgment. And if the bank does file a foreclosure judgment and the foreclosure judgment is granted, then that forecloses, that prevents a lot of the legal remedies that a homeowner may have in response to fighting the foreclosure action. That can be waived. Now, there are various things that can be done to actually try to answer or submit what's called a late answer in response, but it would be the best bet for a homeowner, as soon as the summons and complaint is served on them, to go to an attorney immediately and file an answer. What happens afterwards? Well, there's two directions that the case could take. If a homeowner files an answer timely, or if a homeowner files an answer that, albeit late, the court allows a homeowner to submit an answer via what's through a motion to compel the bank's attorney to accept a late answer. And typically the courts are receptive to homeowners filing late answers, filing and serving late answers. And actually, quite oftentimes, the bank does mandate that quite often the courts mandate that the courts accept the late submission of an answer if there is a reasonable excuse for the delay and if the homeowner has a meritorious defense. So again, it's not an insurmountable obstacle if the bank raises the issue that they're rejecting your answer because it was filed untimely. The courts are receptive to the arguments that the homeowner has a justifiable excuse for the delay. So, if the answer is served timely or untimely, but it is accepted, or the court has mandated that the bank's attorney accept the late answer, the case gets sent to what's called a foreclosure settlement conference part. There is an emphasis on trying to modify the homeowner's loan.